So the state of California just backed themselves into a major corner in the California assault weapons ban case Miller v. Bonta. So let's talk about this. But real quick before we jump into this video, if you think the state of California's ban on so-called assault weapons violates the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, the state of California has now backed themselves into a major corner in the California ban on so-called assault weapons and the Miller v. Bonta case. In a prior video, I told you guys that the state of California filed a motion in the 9th Circuit Miller v. Bonta California assault weapons ban case. In their motion, they opposed the request by FBC to lift the Benitez stay on the purchase and possession of so-called assault weapons in the state of California. But also in their motion, they requested that the 9th Circuit vacate Judge Benitez's ruling and remand the case back down to him for him to have to completely rehear the case all over again from square one. This was the state of California's effort to stall this case out as long as possible because that's really one of the only cards they have left. But in doing so, in their motion, they gave FPC all the arguments that they needed to prove that the stay should be lifted and that the case should not be remanded back down to the court, that judgment should not be vacated, but instead the judgment should be affirmed and also the stay should be lifted. And FPC just obliterated all the state of California's arguments in their reply, and they completely trapped the state of California with their own words. The main argument in the motion to lift the stay or to expedite the case was that the 9th Circuit granted this stay an appeal essentially on the basis that they believed that the two-step approach was appropriate and that on appeal the state of California was likely to win. However, with the Supreme Court's recent ruling in Bruin, everything has flipped, and now instead the analysis as reaffirmed in Bruin is text as informed by history, and that's exactly what Benitez used in his lower court finding. Well, the state of California opposed the motion to lift the stay, and instead they pushed the 9th Circuit to vacate the Judge Benitez ruling and to remand the case back down to him for the case to completely start again at square one in light of Bruin. But in this same motion, they recognized that Benitez and the original order did take into account the text and history of these types of restrictions. And because of this, the state of California likely did more harm than good with their motion here to have this case remanded and for the order to be vacated. Because in response to that motion of the state, FBC filed a reply pointing out all the ways that California proved in their own motion why the stay should be lifted and why the Benitez ruling should be affirmed by the 9th Circuit. FBC argues that first, the state of California incorrectly states that the Supreme Court announced a new framework for analyzing Second Amendment claims in lieu of the two-step approach. Bruin did not establish a new framework, but instead affirmed the existing framework as established in Heller 14 years ago. They then point out that the proper test under Heller was always the foundation of the plaintiff's claims here in this case before the district court, and that the district court faithfully applied that test that was outlined in their complaint and in the original case. This is important because the state of California is trying to argue that the 9th Circuit needs to remand this case back down because it needs to be redone and needs to be reconsidered in light of Bruin. But what they fail to recognize is that the district court did rule on the case in a way that aligns with the Bruin text and the test as outlined also in Bruin, because again, the Heller outlined what the test was. It was text as informed by history. The only issue was that the 9th Circuit and other circuit courts were just failing to apply it. But FBC in their original complaint did point out that very fact that Heller under the true test is text as informed by history. They put it forward in all of their briefings. His history and evidence was provided, and ultimately Judge Benitez did use that as part of the decision down below. FBC points out that California already provided historical evidence of arms prohibitions when they attempted to show that California's ban is one of the presumptively lawful regulatory measures identified in Heller, and California admits that fact, confirming they submitted evidence showing that the ban was consistent with regulations adopted by various states and the federal government in the early 20th century. But the district court considered this evidence and ultimately found that California's ban on modern firearms was not one of the presumptively lawful measures that was identified in Heller, and also they found that the ban on modern firearms has no historical pedigree. In fact, Judge Benitez noted that prior to the 1990s, there was no national history of banning weapons because they were equipped with furniture like pistol grips, collapsible stocks, flash hiders, flare launchers, or barrel shrouds. Judge Benitez also considered the state of California's evidence of state firearms capacity regulations from the 1920s and the 1930s, and also the DC law from 1932. But Benitez ultimately found that those arguments were exactly the type that the Supreme Court in Heller broadly cautioned courts against when deciding whether analogous regulations were long-standing. Because again, something that was put in place or didn't pop up until the 1930s or the 1940s or 50s or something like that, that doesn't actually align with the historical pedigree that the Supreme Court commands that courts must look at. Instead, the history is 1791, during the ratification, and maybe even back during the ratification of the 14th Amendment. But really, the question mainly is, during the formation or the ratification of the Second Amendment, what was the history surrounding that? How did the founders conceive of the Second Amendment back then, and what type of restrictions were in place back then, not the 1930s? Then the brief goes on to dismantle some of the public interest arguments that the state of California is now making to justify the stay remaining in place. FBC states that while California argues that the March 2019 District Court decision in Duncan v. Becerra resulted in a substantial number of large capacity magazines entering the state, California has not provided any evidence to support that the so-called influx of magazines actually caused any real harm, let alone irreparable harm, which is the standard they have to meet. They have to show or prove some sort of irreparable harm to get this stay to remain in place. California has not done any of that. To the contrary, millions of magazines were legally purchased during Freedom Week. They came into the state of California, and we have not seen an increase of any harm in the state of California. It's not the Wild West like they claim it's going to be. Therefore, any claim that a similar influx of AR-15s or these types of rifles coming into the state of California and causing irreparable harm is entirely speculative and not supported by any evidence. So this is important because the only straw California can still grasp onto for this stay to remain in place is the whole issue of irreparable harm, and that they are claiming some sort of irreparable harm will be caused if the stay is lifted. However, like was just pointed out there by FPC, there is no evidence that lifting the stay will cause an increase of crime or any additional harms. In fact, the only basis California points to for that evidence was the Freedom Week decision, and what happened there was million magazines were purchased. However, 3 years have passed and there's no evidence of any increase in crime. Therefore, the entire argument that California is putting forward is null and void. And also, all you have to do is look at the 43 other states that do not have any restrictions on these types of rifles. Do we see an increase in crime in those states? No, we don't. So there's really no evidence to justify this whole argument of irreparable harm that would be caused by lifting this stay. So that is where we currently stand with this case. Our side wants the stay to be lifted, or for the Judge Benitez ruling down below to be affirmed by the Ninth Circuit, or at the very least for this case to be resolved in the Ninth Circuit as soon as possible. The state of California wants the Benitez ruling to be vacated and for the case to be remanded back down to him for the case to completely restart from square one. However, all the arguments California put forward for why the stay should be kept in place or for why the case should be remanded back down to Judge Benitez acts as if Benitez did not consider text as informed by history when in fact he actually did in his original ruling. Also, all the harm California claims that will be suffered if the stay is lifted has also been found 100% illegitimate prior by Benitez himself. So we will be keeping our eyes on this case and see what the Ninth Circuit ultimately decides to do. This is one of those things where we're kind of in this weird area where it really only takes 2 judges on the Ninth Circuit, 3-judge panel, to rule in our favor to lift that stay. And then pretty much we are looking at a bright, bright day for the state of California in the possession of these types of rifles. But again, this is one of those big battles, and this is why I'm talking about this, because this is really the entire battle in this case right now. This is going to determine whether or not we are going to live with this ban in the state of California for many more years to come, and the case is going to be completely redone, or is the stay going to be lifted in here just a few months? So this is why it's so important to be on top of this, to stay up to date, because again, this stuff could change really fast, especially if the Ninth Circuit agrees that the stay should be lifted and that the Judge Benitez ruling should be affirmed. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.